Hello, everyone, and welcome to JFK, the Enduring Secret interview series. From time to time, here at JFK, the Enduring Secret, we get a chance to interview important people in the JFK research community and others that are in some way connected to the story of the assassination. These interviews are often featured on our JFK, the Enduring Secret YouTube channel, as well as our regular audio podcast. If you found us by chance and you are not already a regular subscriber to the audio podcast, please do subscribe at your favorite podcast outlet. And please do the same over at YouTube on our YouTube channel of the same name, JFK, the Enduring Secret. Today is a special update on the continuing questions and puzzling circumstances related to the JFK Records collection. Now, as you know, last year in November, right around the time of the JFK assassination anniversary date, I traveled to College Park, Maryland. And I did so in order to meet Andrew Iler there, along with Paul Blow, another researcher. All three of us spent time inside of the National Archives, right there in College Park. That's where the JFK Records collection is housed. Andrew is the one who initiated this trip, and it was for the expressed purpose on his part of getting at more particular information related to final determination orders, as Andrew knew that these determination orders are key. But in reality, what he found out was shocking. And today we're going to dive right into the topic with Andrew and two other JFK Chokeholds authors, Mark Adamczyk, who is also quite involved in the records question, and Jim DiEugenio. Jim is one of the foremost experts on the JFK assassination, and he has authored many books on this topic, including one entitled The JFK Assassination, The Evidence Today. And this book was the basis for the 2021 Oliver Stone documentary entitled JFK Revisited, Through the Looking Glass. Jim most recently was one of a handful of witnesses that has testified before the Task Force on the Declassification of Federal Secrets, which operates under the supervision of the House Committee on Oversight and Governmental Reform. This is, of course, the committee which is looking into the JFK records and related assassination issues, and perhaps more commonly referred to as Congresswoman Luna's committee. In the past and at various times, you've heard all three of these gentlemen on our podcast. All three of our guests today, along with Matt Crumpton and Paul Blow, who are not with us, co-authored recently a new book entitled Chokeholds. Recently, Mark Adamczyk has weighed in himself on these weighty issues related to the records, sending a detailed letter to Congressman Luna and her task force. I hope she heeds it. This is one of the most important aspects of what that committee was tasked to do upon its own formation. We're still fighting to declassify federal secrets related to the assassination of President John F. Kennedy. Our discussion today is heavily informed by these three experts. Andrew Iler just completed a two-part series that is featured on the Kennedys and King website entitled Critical ARRB Final Determinations, Buried and Ignored. And it lays bare a startling truth about what happened, or didn't happen, with tens of thousands of critical JFK records. Andrew's work forces us to confront a fundamental question. How can the U.S. government claim that full and timely disclosure has been met when the most important work of an independent federal agency has seemingly been buried and ignored for nearly 30 years? For those of you that follow my audio podcast, JFK, The Enduring Secret, you have likely already listened to the preamble episode. I urge you to listen to that preamble episode if you haven't already done so, where I summarize much of what Andrew and Mark have already researched and written about. But today, we've got Jim DiEugenio joining us as a special guest to help put all of this technical information into a better context as well. This is but one moment in time in the history of attempting to get the government to free up all of the records. It's been a long battle over a 60-plus year period. And now, without further ado, let's get right to the interview. All right, we're here tonight with an absolutely anticipated show with great people on it, and I'm just, happy and honored that we have again as guests three people who've been on with us before, and who are really, quite frankly, the experts and the right kind of people to have on to talk about the JFK Records Act and everything that's going on with records, which is such a hot topic in the world of JFK matters. So tonight have with us again Jim DiEugenio. Jim, welcome. Happy to have you. And Andrew Iler, as you know, who's been on a number of shows as well with us, and Mark Adamczyk. Good to see you again.
I think it's important to put JFK, the Records Collection Act, which him and Mark are experts on, in the historical context of what was going on in 1991. All right. When Oliver Stone, when the word got out that Oliver Stone was making a movie about the Kennedy assassination through Jim Garrison, the establishment, I mean the media and Washington, went bonkers. Okay. The Oliver Stone's movie is the only one, and by the way, I went to film school, so I have a pretty good background in film history. All right. Is the only film I can remember or read about that was actually attacked 7 months, and you can look this up if you don't believe me, 7 months before it was in the theaters. All right. And that was just the opening salvo. The New York Times wrote 34 stories about Stone's film before it even premiered. Okay. All right. And so clearly, and then when the week it opened, it was on the cover of Newsweek and Time. This was the week that Mikhail Gorbachev visited New York City. Okay. So the media was clearly gunning for JFK. Okay. And I believe there's two reasons for this. Number one, because the film, exposed how wrong they were in swallowing the Warren Report. All right. And they did. The MSM took the whole thing to heart and took it seriously. The New York Times even excerpted the whole Warren Report in one of its Sunday's issue. Then they edited their own version of the witnesses. Okay. Secondly, Oliver Stone was the first man to actually address the whole issue of would there have been a Vietnam War if Kennedy had lived. Now, I'm not saying nobody ever addressed that question, okay, but he was the guy who actually brought it to a wide circulation audience, and the MSM was not going to put up with this. They were not going to be shown up twice in the same 3-hour movie. And so they pilloried him. This debate went on for a year. But what Oliver had done was very smart, because at the end of the film, he put on this card that said, the last investigation of President Kennedy's assassination, the House Select Committee on Assassinations, their files are classified until the year 2039. And that created an uproar, okay, because everybody wanted to know, well, wait a minute. Why do we have to wait 18 years to see the files of this last investigation? And so people wrote telegrams, they faxed, okay, they made telephone calls, they wrote letters, all right? The guy running the House Select Committee, a guy named Louis Stokes, went to the movie with his daughter. And after the movie was over, his daughter looked up at him and said, "Why did you do that, Daddy?" Okay. And so Congress was now forced to do something, all right, by public outrage. And so what happened is Oliver was a witness, Robert Blakey was a witness, Stokes was a witness. They had these hearings and they came up with something that was pretty much unprecedented. in the whole history of government secrecy. A citizens board of 5 people that would go ahead and work at declassifying every last record that was in the possession of the government. This was called the ARRB, the Assassination Records and Review Board. It had an executive director named David Marwell, and they did their work for 4 years, all right, but they couldn't finish the job. And so, as Andrew and Mark have written about, they used a device called final determination notices to go ahead and do a post ARRB release pattern that, at least theoretically, would make sure that every last document that they saw would be declassified. Now, there's a complicating factor besides the FDNs, and that was John Thunheim's bombshell disclosure at the second Luna hearing. He said words of the effect, "I've never seen some of these documents." And that was very, very much underplayed. Okay.
Yeah, we actually just mentioned that in the preamble. So I'm glad that you're bringing that up because it's very, very clear that there were a lot of documents that didn't get into their hands during.
So the question becomes, where were these documents? Why didn't the review board see them? And that's where Mark and Andrew come in.
Yeah, and I think just to add, Jim, to because I went back and listened to Judge Thunheim's testimony probably 3 times because while it was great on May 20th, I wanted to hear it again. And there's a lot of nuggets in there. And on top of saying we've never seen many of these new releases, he said, and a lot of them were sent to NARA at a later time.
So let's pivot and start from this most recent 8 or 9 months journey that Andrew's been on. I really appreciate that, Jim. I think that puts that in a historical perspective. And Andrew, the work that you did starting back even prior to your visit in November of 2024, but give us the encapsulated view of what's gone on.
Thanks, Jeff. Back in 2020. Mark and I were both very much interested in what was happening post 2017 when the JFK Records Act said that all of the records were supposed to be publicly released by October 26, 2017. And when that didn't happen, just independently, Mark and I started to study the JFK Records Act. And in 2020, Mark and I connected and we did months of deep research into the JFK Records Act and legal issues surrounding how the government and the courts would look at the law and the laws around ministerial duties and administrative law issues with regard to an independent agency and the decisions that an independent agency makes. And we drafted an early version of a lawsuit against President Biden and the National Archivist. And the basis for that lawsuit was that both the president and the National Archivist had not complied with ministerial duties under the JFK Records Act. And the research that we did really led us to discovering a few things that the research community and especially lawyers in the research community really hadn't caught on to in about 25 years. And that was that the ARRB had a mandate. They had a ministerial duty to produce these records or agency final orders that they ended up naming ARRB final determination notifications. And there's different sections of the Act that require very specific information to be included in these final determinations. And in administrative law, agency final orders carry legal consequences. They carry legal authority, much like a court order does. They're different and they operate a little bit differently. And this discovery of these final determinations was quite a revelation, because if they do indeed exist, which is now being confirmed multiple times over by both Judge Tunheim and Jeremy Gunn, and deep exploration into the ARRB records, and legal analysis, both from within and outside the ARRB. They did produce over 27,000 final determinations regarding records that were put before them. And what these final determinations do, they provide a basis for postponing the public release of information in these records, again, in strict compliance with Section 6 of the JFK Records Act. So Section 6 is a criteria that just lays out the reasons that the ARRB was permitted to postpone the release of records. So the identity of a secret agent, a specific source or method of intelligence that would put a current operation at risk. All of the criteria under Section 6 had to have like a current demonstrable harm attached to it. And so all of those decisions that were put out there by the ARRB are in writing. The most important factor that's included in these final determinations, though, Jeff, is the disposition of these records. So when did a record specifically have to go for periodic review by the archivist and the originating agency? And many of them that I found while you and I were at the archives, they showed specific release dates. And for the documents that you've mentioned, I was able to only find 450 initially of these final determinations. But for a large number of those 450, the ARRB specifically ordered that the records be released in January 2006. And Paul Blow and I went through these records with a fine-tooth comb. We matched them up with the latest releases. And what we found is that a very, very large number of the ARRB final determinations, in fact, were not complied with. Records that were ordered released in January 2006 remained kept in secret until 2021, 2023, and even into 2025.
Can I interject here? Because I want to ask Jim a question. This is, there's been such a healthy engagement by so many people over the years. There's been sort of generations of JFK assassination researchers. If you go back to the original folks, the Mark Lane era and so on and so forth, and then those that got involved later, yourself included. But why was this issue not front and center earlier? In the time frame between 1998 and 2017, did they just? Do you think that
between what years?
Well, I mean, the sunset of the ARRB in 1998 and the process that should have gone on between 98 and 2017. Why was the research community not more in touch with this particular aspect of it? What is your view or perspective on that?
Well, one of the problems is that there weren't a lot of people who actually went over the legislation with a fine-tooth comb, and so Andrew and Mark are very good attorneys, and so they had decided to do this. Now, the other reason is that both Trump and Biden broke the law. I don't think I'm exaggerating very much about that. I mean, they relied on what I believe to be a bogus memorandum which both these gentlemen are familiar with,
Yeah,
the Gannon memo,
right, right.
okay, to go ahead and dodge the intent of the law. Now, for instance, I never even knew what the Gannon memo was. Okay, and I think Mark wrote about it first for Kennedy's and King, and he can explain how that subverted the JFK Act. All right, but this is what both Trump and Biden used. All right, in their, I believe, illegal obstruction of the JFK Act. Now, I think that the reason Trump did a turnaround on this is because he made a deal with Bobby Kennedy Jr. that he would endorse Trump if he would agree to go ahead and declassify the files on JFK, RFK, and King. And some of the evidence for this is that his daughter-in-law, Robert Kennedy's daughter-in-law, Amaryllis Fox, is the person who has first pass, and she's looking at all these things. So Trump inserted her she used to work for the CIA, all right, and he inserted her into the process. That's why I believe Trump did his turnaround on this issue. Okay, but what happened here finally is that Mark and Andrew actually wrote about how the law had been subverted. Okay, Mark did one earlier, and then Andrew did a real demolition of what Biden had done. And I just don't think very many people were aware of all the intricacies of how they had done this. Okay?
Yeah, I mean, it's really honestly kudos both to Andrew, to you, and to Mark. There's no doubt. I know for myself, I was completely unaware of some of the mechanics of this until I began to interact with you several years ago, and so it's been an educational piece for.
And let's not forget the way this all started, the way this obstruction started, is that on the day that everything was supposed to be declassified, Pompeo went into Trump's office and read him the Riot Act. Okay? Because if you recall, and I recall, about 10 days earlier, Trump had made a tweet saying, I'm really looking forward to declassifying the last of the JFK files. And that got on television. Yeah. It got on CBS. All right. So everybody's waiting for him to go ahead and do this. Then Pompeo marches into his office and said, no. And he reads this usual CIA, scare thing. Look, if you do this, there's this guy in Morocco, okay, who's still alive, and he's going to get, and that kind of thing. You're going to have blood on your hands, and we're going to put it in the Washington Post. Okay. And so that's what happened. And that's how the obstruction began. All right.
It's certainly been a slippery slope. Can we? I think this is a good moment to maybe segue. Mark, you've been pretty quiet so far, but one of the things which I know you've done lately, and I'd like for you to comment on, is I know as a result of much of Andrew's research, which he has been, I think, maybe an inspiration lately for you, because I know much of what I saw in the letter that you sent to Congresswoman Luna was a function of so many things that Andrew found. But the two of you collectively are probably the most capable minds on this entire topic. When you ask yourself the question, I have two questions actually. One, well, let me ask the first one. Have they responded yet to? Have they acknowledged your communication, and have they responded back in any way to the communication that you've provided to the committee?
Yeah, it's a good question. When I emailed the letter on August 4th to Congresswoman Luna's office, within 5 or 10 minutes I got an email back from her account saying received, thank you, and I'll pass it along. I've heard nothing since. And This gets back a little bit to the discussion earlier about, gatekeepers or what have you, because, that was, I was not trying to get any particular additional line of questioning on any other topics to the case. I think the first two hearings got there was a wonderful collection of different experts and a record was created. But my thought was, hey, you know, there's not really many living witnesses to a lot of those events anymore. Thankfully, we have the experts that could summarize it and educate the committee. But what is alive is the records, and they're going to be alive forever. So I wanted to make sure that there was another voice from the research community that was squarely focused on making sure that the JFK Records collection is as complete and reliable as possible, because I don't believe the stated mission of the task force is going to be complete until that's done. And if they don't have the time to do it, but one of the points I made in the letter was that the Congressional Oversight Committees of the House and the Senate retain jurisdiction over the JFK records collection in perpetuity to make sure the job is done until the archivist can certify to the world that there is a full collection, that everything is out. So that's just some of the points I made in the letter, and but no, I've not heard anything since. I'm disappointed in that because I think Andrew and I would be a wonderful resource to helping expedite that process I just mentioned.
As Andrew knows, Oliver Stone was very interested in some of these discoveries. And so he got in contact with me and he says, Jim, did you know Rubio was the acting archivist? And I said, no, I thought he was the Secretary of State and National Security Advisor. And he goes, no, he's the acting archivist right now. So I'm on the phone with him and I go ahead and punch it in. I go, oh my God, Oliver, you're right. Rubio is the acting archivist. Okay. All right. And so we got together with Andrew and we're sending a letter to not just Rubio, but to Luna and to Trump. Okay. And who else is on that list, Andrew?
I think DNI Gabbard.
Yeah, Tulsi is on it. Yes.
And maybe a couple of the other congressmen on the task force.
Okay. So Oliver is trying to push this envelope a little bit further, and we'll see if anything happens.
These records are sitting there. There's a specific law that required their release and a very, very careful handling of these records. And the information that Mark and Jim and I have put together and is being published on Jim's website, Kennedy's and King. All of Mark's articles and all of my writing is on Kennedy's and King.
I have a real pause on one core fundamental thing. The ARRB's primary purpose, as we all knew, under its charter, was to collect these records and to do what you've described. Yet they did a great job actually going much farther than what their original charter said. They did, in some ways, some of the more advanced investigation related to some of the things that happened in the autopsy and so on and so forth. But and so I think think anybody viewing the ARRB would look at it as a real success story. When you look at the three major, there's more than three, but the three that come to most to mind, investigations, so to speak, around the assassination. But as you guys know, I have a big 8 kind of a background, big 4 kind of a background now, and so I think very analytically about some of these things. And the idea that their principal task would have been to inventory, accumulate, tabulate, and place into a collection all of these records, and then not hand them over in a chain of custody that when they sort of ceremoniously almost to the archivist and say, here they are, it's 27,234, whatever the number was exactly, and here's the computer system that holds them. Here's a detail, line item by line item, 27,234 lines. And there is a perfect chain of custody. And at that moment, then there is a real emphasis on taking the ball, not fumbling the handoff, and then making sure that everything that needed to happen mechanically under the law would have happened. And yet, what you have described, and we haven't really talked about it in specifics yet on this show, but I know we did it in the preamble, is that that document is nowhere to be found. That electronic digital archive document of some 27,000 documents is nowhere to be found. It's the only way that you could have possibly administrated the scale of these records and the obligations that were required for each record. So to the extent that it's not available now, and to the extent that no one can produce evidence that it ever was around or available, then there's a sort of prima facie evidence that they never intended to administrate it that way from the very beginning. And I have you can go as far down into the details as you want, but that is the fundamental transition and handoff, and there's no evidence that there was any infrastructure whatsoever addressing it. Am I incorrect in that?
Oh,
You know,
Andrew, you go first, and then we all probably have something to say about it.
yeah, Jeff, this is the most upsetting thing to me is that the ARRB, the apex, the culmination of all of its work was the issuance of these final determinations. And you're absolutely right. The law required that not only these legal orders be sent to the National Archives, the Archivist of the United States had a legal duty to enforce and implement these orders under the Act. It was non-discretionary. The Archivist had no discretion whatsoever. But where the hell are these orders? They were ordered published annually in annual reports by the ARRB. The ARRB was supposed to publish 4 or 5 annual reports. Only 2 were published. Yeah,
Okay.
and you know what? Listen, I mean, I've communicated directly with Judge Tunheim and Jeremy Gunn about this, and I went on a goose chase for the annual reports for every year that the ARRB was in operations, and there are only 2 reports. The law stipulated that within each annual report there had to be a specific appendix that included all of the final determinations issued in that specific year. Well, what I found, only 2 reports were issued in 95 and 96, and only the 1995 annual report had an appendix with the final determinations. 96, there was an annual report, but no appendix with final determinations, and no annual report was issued in 97 or 98. So the public was supposed to have access to these final determinations in the annual reports. But not only that, the ARRB was supposed to send copies of the annual reports to the President, to Congress, to the National Archives. The law also required that the ARRB send the National Archives copies of every single final determination notification. Not only that, and I found records that showed in 1997, there was a whole backlog of the issuance of these final determinations, and they initiated in June of 97 a project aptly called the ARRB Final Determination Project, where they tasked staff specifically to attach copies of the final determinations to each assassination record before the assassination records were transferred over to the National Archives for cataloging and to become part of the collection. Not only that, I found an email, an internal ARRB email from October of 1997, where the ARRB staff are talking about a telephone call from Martha Murphy. Now, Jim's familiar with who Martha Murphy is. She was a senior archivist at the National Archives who was mainly responsible for the JFK Records Act. Well, Martha Murphy was monitoring the receipt of the transmission of all of the records into the National Archives from the ARRB. Well, she called, I believe, Eileen Sullivan at the ARRB in October of 1997, and she said, "Hey, Eileen, we received 2 records from the ARRB that did not have final determination notifications attached to the front of them. We can't process these without the final determination notifications." So the National Archives wasn't just some passive repository for the assassination records. They were closely monitoring the transfer and documenting the transfer of every single assassination record. And they were picking up on the fact that if a record didn't have a final determination on it, it couldn't be properly processed.
But I mean, let me break in, because I would interpret that as there was somebody at the National Archives at the time who was studiously looking to determine that those were there. And that implies to me that there may have been staff very dedicated to trying to follow the letter of the process, but ultimately somewhere along the line, the chain of custody is such that those final determination orders that should have been attached to every one of those individual records was removed, and or somehow disattached in a way that now makes it very difficult to consolidate them again.
Well, Jeff, we know that the final determinations were 100% absolutely attached, physically attached to hard copies of the records when they were transferred to NARA. We know that when NARA handled them, whether it was on review or whether it was when they were releasing them in 2017, 2018, all the way to March 2025, we know that if they took one of these records out of the protected collection that was withheld, it should have had one of these final determination notifications on it. And before it was digitized and made public, they had to remove that final determination notification. I guess the big question is, well, and we also know from the IT specialist who was at the ARRB from the very beginning to the very end, that all of the electronic records of the ARRB were also transferred in computers and storage disks on servers over to the National Archives, so the National Archives could maintain that electronic system of ARRB records, which included diarizations and calendar notifications for the release of records, as well as access to all of the ARRB final determinations. So not only did they have these things in hard copy, they also had the entire ARRB system that was transferred over there. And somehow, because you know, and you've mentioned in your intro, I've done FOIA requests. I've been to the National Archives. I've specifically asked for all of these records. These should have been publicly facing records. Both Judge Tunheim and Jeremy Gunn said, even for the records that remained withheld for legal reasons, the final determination notifications were always drafted and created and issued to be publicly facing.
I have 2 questions as a follow-on to that. One for Mark first, and then one for you, Jim. And the one for Mark, Mark, I know this has been a particularly flagrant topic for you. I know this really is something that motivated you to write the letter. Jim, I'd like Mark to comment on that, and then after he does, Jim, if you could comment on this sort of this general idea about the fact that records that should have come out in 2006 that didn't, and came out 19 years later in some cases, are during an era where most of the important witnesses were aging. Many of them died somewhere between 2005 and 2017. And so the reality is, the hypothetical is, would we have known that much more? And would it have made a difference in the way that we were able to address some of the living witnesses that we can't now because they're gone? And we're just learning about this information. I think that's a really critical aspect of what the effects of this delay have been. And so before you answer that, I'll give you an opportunity to think about it. But Mark, tell me your feeling about this whole circumstance of mechanics.
Yeah, you're right, Jeff. It does hit home with me. I think it's just outright shocking because the like as Andrew said, the most important work of the review board, its chief and only function for the most part was to make decisions on postponement requests, right? That was its job, and they did it in over 27,000 instances, issued a final order, and went through the process that Andrew mentioned. I put in my letter to Congresswoman Luna the email response that Andrew got to his FOIA request in this June, where they said they could not locate a set of final determinations. Those were the words, which is a remarkable response considering you all found about 450 of them by complete accident in a mislabeled box at the archives, right?
They're still
So
in that mislabeled box, by the way.
yeah.
That's why they can't find them.
No, but let me big picture. I wanted it's incredible that Andrew was able to drill down to the legal importance of the final determinations. Nobody had really looked at that before, and it's just groundbreaking. So that now we know that it's a final order. We now know that President Clinton did not override a single review board decision, because he had an opportunity, an appeal opportunity under the statute, 30 days. He said, I'm not doing it on any of them. Let the review board do it. If the agency has an issue, they can work it out with the review board under the process. Their decision is fine by me, right? So we know that there are enforceable decisions on declassification. The reason I think, and this is, I think, my best educated guess, that it is problematic for the archives to not only they won't even acknowledge their existence, okay, even though we know they exist, and Andrew's drilled down on that. They can't acknowledge them or produce them because it creates a written record of what in the current JFK collection, so to speak, was not reviewed by the review board. Because if they had 27,000 final determination notices released to the public, my gosh, how many more records in their so-called collection? It's got to be 1,000 times fold. Were not reviewed by the review board. Were transferred to NARA before the review board could take office and after, and handled in a completely separate manner by the agencies and the archives, who had no authority to do that, for from 92 all the way to 2017, with that short 3-year period where the review board made binding decisions. So it creates a record of what the review board never saw. It creates a record of what was transferred to NARA before the review board. For example, the HSCA sequestered collection that I mentioned in my letter to Luna, and for 98 to 2017, for all the document dumps, record releases we saw between 98 and 2017 in the black hole of unknown periodic review after 98, it creates a record of that too. So,
But Mark, I just want to stop right there. That's so enormous what you've just said, right? It's really what we're not seeing that is so fundamental. And you've just laid this out probably in the best way that I've heard it yet. Those final determinations are just the tip of the iceberg.
it's the foundation. It really is. Yeah.
I didn't mean to interrupt. You
No,
keep going, man. That was huge.
You've opened and we'll get back to this. I want you to hold it, but you've opened up what really is one of the most important topics of this conversation, which is the issue of the sequestered record collection. But let's get back to that, because I want to hear now, the bigger picture of the records is that getting to the records is a means to an end, should be, in all of this. It's not just about the records themselves, although there's the issue of transparency that the government has an obligation around. But in the context of the JFK assassination and the solving of this case, if it ever can happen, there's been impact here, I think, and I'd like to hear Jim's historical perspective on that.
Well, I think you're trying to ask me, if there would have been a difference. If, to give you one example, according to Paul Blow, and Andrew, there's still documents classified about Oswald in Mexico City. All right. Now, that's amazing. This is now how long? The Lopez report was declassified in about 1997, completely, almost completely. All right. And here we are, 28 years later, and there's still files classified on Mexico City. Now, this has always been a very special interest of mine, okay, from the beginning, because the Warren report was completely hapless on Mexico City. In fact, they couldn't even interview Sylvia Duran, who was the most important witness about Oswald either being there or not being there. All right. And there's always been this debate about that issue. Was Oswald there or was he not there? Now, one of the things the ARRB did declassify, but this was on a delayed basis. Malcolm Blunt found it, I believe, in 2003, was the original draw from the photographic station in Mexico City, which clearly says Oswald negative. Okay, in other words, there was no picture of Oswald when they went to check the directory. All right. Now, how could that possibly be? Now, according to Paul, what these files that are still classified deal with is voice comparisons. All right. Now, here's my question, and this is Paul's question. If David Phillips was telling the truth, how could there be a voice comparison? Because he said that those were destroyed within 7 or 8 days, okay, after they were recorded. All right. In other words, this is a lie. Okay. Some of the voice comparisons did survive. All right. I want to know what the results were, because this is a very important point. When they were sent up to Dallas and the FBI agents interviewing Oswald listened to them, they told Hoover,
wasn't him.
The voice on the tape is not the guy we're talking to. Okay. So where are A, the pictures, and B, the voice comparisons? Did the CIA know that they didn't have a voice comparison? That's sure as heck what it sounds like to me. And that we cannot read these reports in the year 2025 is simply astonishing to me. It really is shocking that here we are, what is it, 63 years later, and we're still in the dark about Oswald in Mexico City? I mean, that should really be sickening to anybody listening to this show.
Yeah, absolutely. And, and honestly, it's one of those, I think, poignant things that as we come back around and say, what can the Luna Committee really get at? What are some things that are really pressing still that are, I think, material to understanding what actually happened? That's one of them. Let me just pivot, because Mark, you opened the door for this, and this was eventually going to be the big sort of topic, I think, tonight, is the sequestered record collection. And if I have it wrong, you guys can correct me, but the simple story on this is that right after the JFK movie came out, it was very clear to the CIA that legislation was pending and would likely come into play and would likely affect the disclosure process for records that obviously they wanted to keep secret. And as a result of that, they took steps, and they were later identified as a result of some of the documents disclosed. They took steps to actually try to accelerate the delivery of certain of those documents, certain collections, the sequestered collection, in order to ensure that it would be handled under the existing historical CIA rules for disclosure, and that it would in some way be shielded from whatever was coming in the provisions of the JFK Act. And obviously the idea there was that they would have a greater control, if not ultimate control, over whether they were released, when, and if ever. So do I have that correct? Is that pretty much the story on those records? And what I want, I think, to hear from you all is what is your sense? First of all, give any color commentary and correct anything I've just said.
You know, the thing about it is the JFK Act, right, required all of these records as of October 26, 1992, from any government office or agency, including government investigation records of the Church Committee and the HSCA records, to go to the archives. There is no exception. And the JFK Act also said that the standards of review in the statute to be implemented by the review board superseded any existing law, national security order, FOIA, court order, court seal, what have you, that may have been in play at the time. So obviously the CIA took that as a light suggestion and came up with the plan to get the HSCA sequestered. Sequestered means confiscated or seized in plain English. I thought that was humorous when I looked up what sequestered meant. To take what I believe its most sensitive records, maybe provided a sampling of them to the review board to play along, and then almost certainly kept the most sensitive records. And you heard Judge Thunheim, in his own words, on May 20th, said it didn't take a rocket scientist to see that they were waiting us out. Jim talked about on April 1st how hard it was for the review board to get through a single document with the CIA staffers. It took hours and hours, right? And so that was what they did. And now the status of them is largely unknown. And it wasn't up to the agencies themselves under their own guidelines, and certainly not the archivist as their puppet for 20 years after the review board was done, to continue to handle these how they wanted. So it's an important document, and there's going to be more out there like that. We're thinking we're doing a deeper search into follow up on that memo that we think could be out there.
But the ARRB would have been able to see the document. Who knows whether they would have had time to actually deeply review it, because in the final weeks, it was like helicopters flying out of Saigon at the ARRB. They got massive dumps of records. They were just scrambling to try to finish their final report. And at the beginning, Oliver Stone's JFK film and the release happened in December 1991. And within days, the CIA had like a rapid reaction. I don't know whether they knew that the final screen of JFK was going to hit the American audience like it did and cause that kind of reaction. But within days of the release of JFK, they were having very, very high-level meetings at the CIA on how to contend with this. And the memo that we keep talking about, and you mentioned it in your introduction and in the promo, there was a February 10, 1992. So we're talking a few weeks after the release of JFK, a month and a half after the release of JFK. And the senior historian in the Historical Records Group was asked by the Director of Central Intelligence to put together a memo that essentially lays out the whole catalog of House Select Committee on Assassination records called the Sequestered collection, and what was in it. And then the director of Central Intelligence, more importantly, goes, what the hell should we do with this stuff? And essentially asking the one of the senior historical records group guys to come up with a strategy on how to best protect the classification of these 64 boxes of House Select Committee and other top secret records. And so this guy, Kenneth MacDonald, the historical research group head, he sat down, and I think the DCI asked him on January 16th to come up with a strategy. And so on February 10th, 1992, that's what he did. We're talking a very short time after the movie was released. But more importantly, we're talking 8 months before the passage of the JFK Records Act. And so 8 months before, they're talking about a strategy on how to circumvent or get around what they anticipate will be coming legislation to declassify all of the CIA's JFK records. And the most amazing thing to me was, clearly in February 1992, they didn't have a copy of the legislation yet. They didn't know exactly what was going to be in it. But they said, we got to get these records over to the National Archives so that we can protect the current level of classification and have the archives basically play cover and be in charge. But oh yeah, we'll fund the positions and staff the positions
Yeah.
that are going to review these records. Yeah. Okay. But this was 8 months before the passage of the act. When the act passed in October of 1992, it included this section 5D3 of the JFK Records Act that stated any records transferred to the National Archives before the passage of the act don't require a RIF number or review by the review board if they've been fully released and unredacted. Okay? So the problem that we all have is we don't know what was transferred before the passage of the JFK Act, and now with Judge Tunheim's statement that the ARRB never saw many of the records because the records were transferred after the ARRB went out of business. We have a two-pronged problem here. And Mark just hit on it 5 minutes ago. It made me excited, what Mark said. You know, the fact that the final determinations were ignored is one thing, but that will create a clear record of what actually the ARRB looked at. The stuff transferred to NARA before the passage of the JFK Records Act and transferred after the ARRB went out of business, they would not have possibly been reviewed by the Assassination Records Review Board. So how did all of those records get handled? What's the status of those records? On what criteria were those records withheld from the public?
Is there any indication, Mark and Andrew, this is probably more for you because I know you've been in the details of it so much. Is there any indication that any of the records that might have been in that sequestered collection have found their way in and do have RIFs or have been disclosed? Do you have any evidence that there's at least some things that have been disclosed out of that collection?
So yes. Yes, and I mean, I'm in communication with Joe Bax, who is a long time records researcher. You know, even the people who are so deep in the weeds with the National Archives and the records, they all acknowledge Joe has a database. He's tracked the processing of these records. He's advised that probably a large portion of that HSCA sequestered collection was transferred to NARA and received RIFs. Okay. But even Joe is like, it's the likelihood that all of the records were transferred. There's a good chance that many records were transferred before and maybe didn't receive RIFs. What Mark and I, and this is speculation, I don't like to speculate, we think the CIA was essentially testing the system throughout the existence of the ARRB. And what I think we're seeing now in a lot of the records in the 2021, 2023, and 2025 releases, we're seeing some suggested evidence that those records were not transferred to the National Archives until after September 30, 1998. We're seeing a lot of records that look like they were transferred in the year 2000, and there are codes that NARA keeps that show exactly down to the millisecond when a record was received at the National Archives from an agency. And some of that metadata is suggesting that a large number of the records ended up being withheld, because really none of the agencies knew how the ARRB was going to handle the records when it first started its work in 1994. And so it was kind of a touch and feel process as it went along. No one knew how President Clinton would handle appeals under Section 9D1. Now, as we know, I discovered earlier this summer that President Clinton approved a memorandum of understanding with the ARRB, and that memorandum of understanding said only written overrides are needed to override an ARRB decision. But if the president didn't provide a written certification overriding the ARRB decision, then that ARRB decision became the final binding and enforceable order. And that memorandum of understanding has never been, the approval by President Clinton was at the Clinton Library, and they provided a copy of that. That's the first time anyone's seen that.
Regarding the sequestered collection, when we see releases nowadays, 23, 25, like Andrew mentioned, even if it has some more materials from the sequestered collection, we don't know that it's everything or a portion of it or how much of it really is, for two reasons. The lack of the final determinations to know if it was seen by the review board, that's a record of that, and the lack of a functioning, searchable, reliable catalog at the National Archives. So someone like the four of us could go on a checklist and say, oh yeah, that NARA had that. And now it's been released. So until you have the final determinations and an actual reliable inventory of what NARA actually has and when it got it, we don't know. These releases mean next to nothing when they come out and the media makes a big deal of them, and they're great, but we don't know really what it is.
I want to stop and pull all of you. Do you think there are material records? What do you think, Jim? What do you think? Do you think they have documents that they haven't turned over?
The person that was involved with this for ONI, okay, she tried to comply with the strictures of the ARRB, and she was fired. She lost her job over this. So, yes, according to Jim Lazar, I talked to him about this, and he talked to somebody in military intelligence who said that we disposed of a lot of these records before the JFK Act was passed. All right. So yeah, there was, and the see, one of, I believe, the failures of the ARRB was that it didn't have a strong enough investigative staff. Okay. They should have had a team of investigators whose job was solely to find out where these records are, okay? Who has possession of them, and precisely at what place they are located at. All right, and I think most people would agree that the ARRB was underfunded, but that was one of the very, very serious shortcomings of the review board.
Andrew?
Yeah, I mean, I clearly think that there are still records out there. I think that records were destroyed. All in all, look, if we could have walked away from the ARRB's 4 years and had the media cover what Jeremy Gunn and Doug Horn brought to light with the Bethesda autopsy, and there not being major discrepancies between what the Parkland doctors saw and witnesses at the autopsy, I think that that was enough of a victory that we could go, let's open a new investigation now. Clearly, the Warren report and the HSCA did an injustice to investigations, and we actually need a real investigation. So, yep, there are still records out there.
So one of the things that got highlighted right as this process was pivoting with President Trump as he came into office was a mandate to review documents, and there were some 2,700 documents I recall that the FBI proffered as being new. I'm not familiar much with that component of the collection. Can any of you comment on whether these quote new documents were actually fruitful in any way, and then why were they secondly, why were they not found before? Was it just a
They
better
were. They were found before. They were known by this FBI, and it was acknowledged, I believe, by Tulsi Gabbard that those records were known while the ARRB was in operations, and they were not transferred, despite there being knowledge of these records.
Okay. I mean, I think that's important for folks to know. It wasn't something that was just found as a result of the mandate. Do you believe that there is given the comments you all just made, someone might be a skeptic and say there's little one could do to search these agencies, but should there be a part of the process that says we're going to start with, from ground zero again? We're going to go back and we're going to have a comprehensive methodology to go through old documents and determine if anything else needs to be gathered up and sent, or has that moment come and passed?
Well, I think it's one thing to go into all the agencies' offices and raid them, but I certainly think, and I've included this in my letter to Luna with some recommendations. It starts at the archives itself. We until there's depositions, hearings, subpoenas of what the archives got and when and from whom and how it was handled internally, we need to start there for sure. Because right now we're going on an unreliable catalog, and they won't even provide the review board's actual work.
Jeff, the Judge Tunheim is a very measured man, and his testimony on May 20th, to me anyway, I listened to virtually every public statement that Judge Tunheim has made over the last few years about the state of the JFK records. On May 20th, he made a comment under oath that really dumbfounded me, I have to say. He stated to the task force that by the time of the October 2017 ultimate deadline under the Act for the release of the records, there should only have been 1,500 ARRB redactions outstanding. And what we did see in October 2017 is somewhere between 31,000 and 45,000 withheld records. That far exceeds what Judge Tunheim said was left outstanding by the ARRB. And what we've seen even in 2025, if you go into the 2025 releases from March alone, there's more than 1,500 records that have been unredacted or released just in 2025. The scale is by magnitudes of like uncountable magnitudes.
Good point. So let's address the elephant in the room. You just talked about order of magnitude. Should have been 1,500 redactions. There's 30,000 or more, 45,000, whatever the actual number is. It's a scale that's almost unprecedented. And obviously, there had to be good intentions about the lawsuit that was recently filed, but we all know the lawsuit is failing, and there will be a limited success in whatever it is that comes out of the finality of this. It appears anyway, based on how it's progressed up to this point. Is there a path in this for a second lawsuit that's unrelated to the issues associated with what were litigated in the first lawsuit that might be helpful? What is the path to forcing the government to do this? Or is it just simply that there has to be enough awareness that occurs that it results in additional, more stringent legislation that goes beyond even what the JFK Records Act is legally entitled to at this moment in the court of public opinion?
Mark, you want to take that one?
I think if you just really look at the statute itself and see the oversight authority that Congress has over the records, you know, they could finish the job without the need for a new lawsuit. And all I did, and I know Andrew's tried to do, is lay out the legal issues and the investigation, and just to get to the archivist, to the point where under 12B of the JFK Act, you can make a legitimate and truthful certification that all the records that it ever collected since 1992 are fully released to the public, and that's what this statute's supposed to accomplish.
See, one of the problems with what has happened, I mentioned the what I believe to be the illegal acts by Trump and Biden, but the other thing is that one of the most important aspects of the JFK Records Collection Act was that there was supposed to be oversight. Okay, and this could have been done by either Congress or NARA, okay, the chief archivist, all right, who I believe was Martha Murphy when the back in 1998. I might be wrong about that. But to my knowledge, and to I think these two people's knowledge, there has been no oversight. I mean, Luna she's not the oversight committee. She's a subdivision, okay, this special task force. So she's obviously not as powerful as Mr. Comer would be. You know, Mr. Comer would have the right to actually call people before him, subpoena people before him, and ask them very difficult questions about why, and this is another problem, why is there no serviceable index to every single record, okay, that you have there, all right? And by the way, that's part of the law, okay, that every record had to be properly indexed, and the ones that were still outstanding, they had to have a description of what it was about, all right? And these have been terrible failures, I believe, that Congress has simply, you know, to put it in rather rough terms, Congress has simply rolled over in this situation. They've completely abdicated what they should have done, when in fact the JFK Act, I believe, was passed without a dissenting vote. All
Unanimous.
right.
It was a unanimous vote.
Right. And so, but neither the Senate nor the House has ever called one hearing on why it hasn't been abided by according to the actual record. Okay. So this is another very serious problem. All right. That you might want to launch a second lawsuit on this. All right.
Those are very important historical perspectives, Jim. Uh, if you all had control of this process for a day, so to speak, what's the one most important priority that we have to gain advantage to in this moment that we have before us? This is a rare moment, I think, that once again, and it doesn't come around very often. There haven't been very many seasons of this in the 63 years of the period of time that's gone by since the assassination. What is it that we should be seizing the moment for? What's the big thing that should come out of this? Obviously, what you just said is a big one, I think, Jim. But is there any other uh, uh, aspect of the records reveal that you would want to see, or a focus on a particular area of records that we're missing? Is there anything
Yeah,
that?
Jeff, I think number one, people should go onto Kennedy's and King. They should look at Mark's letter to Representative Luna. And I know the letter that Oliver Stone wrote a few weeks back. They focused on some of the very most important points that we now have through Representative Luna's task force. Call the archivist for questioning in front of that task force. Call representatives from the CIA and the other agencies. You can't possibly have a task force that just has some witnesses that do not include the archivist, who is responsible, legally responsible for the maintenance of the collection, for the creation of an index and catalog of records, for the handling of records, for the implementation of the ARRB final determinations. I think it's absolutely essential for this task force on government secrecy to understand how the agencies who have implemented that veil of secrecy over the last 60 years get answers from them. Here's our chance.
Jim, I want to pivot on that point, because I think you can provide some perspective. The research community has been not necessarily internally, but certainly externally, and certainly by the CIA and other interested agencies, divided into the lone nutters, so to speak, and the folks who believe in conspiracy, as a pejorative dichotomy. And I wonder if it is relevant in this process to finally open the patient surgically, so to speak. We may not get to the answers on who was involved in the assassination, or whether the CIA or members or some rogue group were culpable by this process, but wouldn't we expose very specifically, if we were to subpoena these individuals and have them come before Congress and have to tell just exactly the mechanics of how things happened, who was involved, what was the process that resulted from this, or was it just benign neglect? And we shouldn't be doing anything but criticizing the government for falling short, which they do in many areas, not just the JFK assassination. I mean, I think there's a real question here. And I know you've been, for many years, just because of your position within the research community, you really, this sensitivity has to be front and center for you. How do you feel about all that?
I agree that there should have been a hearing. Was simply, I would have just asked Thunheim to be there, I would have asked the chief archivist to be there, and I would have asked Comer to be there. All right. Now, Luna would be in a very sensitive situation if she subpoenaed her boss. Okay. But I think that would have all been very illuminating. All right. I would have asked, you know, what broke down in order to get a complete failure on the National Archives function, which was to provide a full and serviceable index to all the records that were sent over there by the review board. Why did that completely break down? I would have also asked, you know, why has there been no oversight, okay, which is, I believe it's in the actual JFK Records Collection Act. There's supposed to be what it was called a periodic review. To my knowledge, there's been no periodic review. All right. And I find it very, very hard to believe that in such a high profile instance, I mean, is there any other issue that has more attention to it than the JFK case in a historical sense, in an archival sense? I find that hard to believe that it could just be a mistake or just something that they fell down on, you know? And so I think that's the only way you'll get to the bottom of it. If you call some people on the carpet, you know, and ask them, what is going on here? You know? Do I think that's going to happen? I doubt it, but that's what should happen.
Yeah, there's no doubt that seems like that really is the proper course, you know, given what we know today, and particularly what Mark and Andrew have added to the richness of what we know behind the scenes. We've covered a lot of ground tonight, guys. I think what I'll do is pause here, and I'll ask if any of you want to cover any other topics or want to add a final word, because I'd love to have you add a final word if we're at a point where we can do that.
Sadly, today we don't have an Oliver Stone's JFK being released to spark the public's interest in this now 60-plus-year-old assassination of a president and a clearly problematic governmental response. But I mean, Jeff, even your audience can call their congressman's office, congresswoman's office, and say, "Hey, this is an issue that I care about, and you need to keep conducting oversight on this, whether it's through the task force or through the full House or Senate oversight committees. We need to get to the bottom of this. Answers need to be made about how these records were mishandled, particularly. That's one thing Congress can absolutely act on. And they do have a legal duty, as Jim says, to do oversight on the JFK Records Act and the status of the JFK assassination records collection. That's their job. And they should be doing a full job at this late date, even at this late date. And even a few calls from your listeners, a letter is very powerful. And you can email your congressman or congresswoman's office and say, "Hey, I care about this. Please make sure that all the records are accounted for and that they are fully released." And I think that makes the biggest difference right now. It's not a JFK film, but the public still does care. It's one of the most. It's still one of the matters of history that creates the most concern for Americans.
Jim?
Yeah, if I can do a commercial, Okay,
Yeah, sure.
if you don't mind.
Of course.
See, Mark and Andrew were contributors to this book, the JFK Assassination Chokeholds. And I believe that this was one of the very few, if not the only, book that's out there that actually tried to address this issue. Okay? And don't ask me why. Okay, don't ask me why it's the only book out there that did that, because I think the issue should have a lot more attention. But that's a fact, you know. So we were lucky to have these two attorneys who were well versed in the JFK Records Collection Act reporting in that volume. All right. So, and I hope your show reaches enough people that we can have at least a little bit of a reaction to this. You know, either go ahead and call up Comer, go ahead and call up the archives, okay, write a letter, okay, send an email, you know, whatever you can do. Every little bit, you know, helps. All right, so I'm glad we had this discussion tonight.
I am too. And sure. And Mark, we'll leave you with the last word here.
Yeah, I'm glad Andrew mentioned the fact that while we don't have a movie like as powerful as JFK having just come out again, but what your listeners can do is remember that that movie led to the creation of this Records Act, right? Unanimously passed by Congress, and to remind their constituents, their Congress people, that law has not even been close to be in compliance yet, right? So if we can keep the spirit of what the public were so upset about in the early 90s, which led to strong action by Congress, and ask them to do that again, knowing that there's not compliance yet. And let's face it, you know, for the task force, this is the only assassination or tragedy that they're investigating that has a law behind it, and that's important. So start with that, get that in compliance, appoint a new review board, an independent board of civilians that is similar to the first review board. After there's a full collection of records with a reliable index, then the new review board could continue the declassification process, possibly with Trump or a future president, possibly having to make a final decision on a specific batch of records and be done with it. And that would be a great result.
Fabulous. These are all great comments, and this is really going to be enlightening for everybody who listens to this. So I appreciate this from all of you. You're all gems. You're all a really big part of what is continuing to help solve this. And I hope someday that we can actually say that that's occurred. Thank you, gentlemen. It's been a pleasure to have you on. It's another, I think, great episode that all the listeners will love, and they'll be more educated after they get through it. So thank you. Thank you again for listening today to another episode of JFK, The Enduring Secret interview series. Please join us on a regular basis, and you'll find our podcast at your favorite podcast outlet, as well as our YouTube channel on YouTube. And that's JFK, The Enduring Secret.